Well, everyone, we often hear how the law is supposedly on our side. I think we sort of comfort ourselves with that. Anytime that you get arrested for a meme, eventually there are champions of our rights and liberties, like ADF International, the Free Speech Union, who say, don't worry, we will win out in the end. And they have won some important legal cases. But even if you do appeal to the tools of the enemy, like the Human Rights Act, the ECHR, or the Equality Act, even if they do net us some wins, like realising biological sex or trying to reduce the number of thought crimes recorded by the police, what matters less than the letter of the law, it turns out, is who is applying the law. And so we'll be going through some new examples today just to show you how much the state hates you. That's basically our job over here at lotusheats.com. The other job we have is producing amazing things like Islander magazine. If you read the first issue, well done, you're a man of culture, I see. If you missed out on that, we have now issue 2 that our intrepid editor Rory has been working on diligently, sweating away, doing all the art, getting all of the articles together.
He has been sweating, he stinks.
Yeah, he honks, he reeks. That mullet is just dripping. Anyway, we have essays. We have more essays this time around. We have essays from Cole, we have essays from Raw Egg Nationalists and Neva Parvini. We also have new writers like Dave Green and Stefan Molyneux. So, if you are curious about what they've written for this Apocalypse edition, you can go and pick it up for $14.99. Same price as last time, but more for your money. And because we listen to your feedback, this time we are printing in batches rather than pre-ordering, so it should mean that as soon as you order, and links are down in the description, you should get it within 2 to 3 weeks, so long as whatever country you live in doesn't try and stop you from getting the gloriousness of Islander at the border. We also have lots of new merch. This is back there, and I pressed the wrong button, didn't I? There it is. The new merch, which is all of these wonderful design t-shirts. They're also limited edition, so as soon as Islander 2 goes out of print in, how many weeks is that? Do we know? Okay, 4 or 5 weeks. So in about a month or so, this is no longer going to be available. So quickly rush down to the shop. By the way, I wasn't listening to the voices in my head. It was my producer. I'm sane, I promise. Anyway, let's quickly move on. First example of this. Some bloke sent Jess Phillips a death threat. I think this is a good example to contrast the 2 tiers of justice in the UK. So we're glad that this man, Nabil Arif, I'm sure she'll say he's just a man of nondescript identity from no particular location whatsoever. Moving swiftly on, and we're glad Nabil Arif has been jailed. He's only been sentenced to 12 weeks. He sent Phillips some abusive messages, beginning from the Israel-Gaza war in October 2023. In one message, he told Jess Phillips, "Hell is real and you will burn," and in the last email, he said that he will burn her till her skin is no more. I mean, that's disgusting, it's a death threat. He should get far longer than that, I think we all agree. The Crown Prosecution Service said he was sentenced to only 12 weeks after a trial at the same court on the 29th of July, and he was made the subject of a restraining order, so he shouldn't ever contact Phillips again. Curiously, though, and I want to note this, at the bottom of this article, they include some details about the Israel-Hamas war. They say 1,200 people were killed in Hamas's October the 7th assault, close to 41,000 people were killed, according to the health-run ministry in the Hamas-run territory.
Wait, so Guardian just dropped that in at the end of the article there, almost as like an excuse for why he was making those claims.
To contextualise it.
Yeah.
So, see how this is treated, both by the Crown Prosecution Service and the Labour-friendly press, because
the Guardian basically hinting, well, she was kind of asking for it.
Yeah, quite. Because, contrast this with the Guardian's reporting on this woman. This is Julie Sweeney, for those who don't remember, of Church Lawton, Cheshire. She pled guilty at Chester Crown Court to sending a communication to convey a threat of death or serious harm. She was jailed for about 2 years, and she said something that is far less a direct threat, still very inadvisable, don't do it, it's silly, but far less a direct threat than what the prior gentleman decided to say. So she was part of a Facebook community group with 5,100 members, responding to a photograph that showed a number of white and Asian people involved in cleaning up after Southport. She posted, "It's absolutely ridiculous, don't protect the mosques," and she said this, not me, "blow the mosque up with the adults in it." Again,
yeah, it's a bit extreme.
Stupid, disavow. Was she with the imminent ability of doing that? No. Was the other fella more likely to be able to do that to Jess Phillips? Certainly. We know this because in Jess Phillips' own constituency, there were masked Muslims that were armed, attacking pubs and publicans, occupying a roundabout and threatening people in cars, which Jess Phillips herself tried to obfuscate for, by the way. And so the sentencing judge, Stephen Everett, jailed her for 15 months, so a bit over a year and a half. no, sorry, just under a year and a half, telling her, "You should have been looking at the news and media with horror like every right-minded person. Instead, you chose to take part in stirring up hatred. You had a big audience. You threatened a mosque. It was a truly terrible threat."
So it's not enough to tell this woman that what she posted was incitement of violence. He had to give her a little moral beating as well. Tell her that here's how you're supposed to think. I know that this will be reported in the newspapers, so I'm going to signal to everybody reading how they should feel about things.
Well, he says here, so-called keyboard warriors have to learn to take responsibility for their language, particularly in the context of the disorder that was going on around the country. Remember that phrase. The context of what is going on broadly, more politically, influences the justice system. That is the point they're making there.
Well, and it's also important to remember that when judges make statements like this, they're not making them for the person that they're sentencing. They're making them for the newspapers to report on, so everybody can read what you're supposed to do.
And to set precedent in law for future cases. That's also the important thing. Also, important to note for The Guardian, notice something missing at the bottom of this article. It's context about the Southport massacre that would have otherwise explained why Sweeney was so angry, unlike the prior article that ends with details about Gaza, from the Hamas-run health agency as well, very reputable, that tries to contextualise why Arif sent Jess Phillips' reprehensible death threat. So again, two-tier reporting, two-tier justice system. So speaking of the right to protest, Policy Exchange have a report out on the pro-Palestine protests. You can go and download the publication in your own time, give it a read if you have the time to read a 150-page report. I wanted to pull out some findings from this because we can see here that the attempt to ameliorate the justice system and the police and the Crown Prosecution Service by principles and legislation and a mandate to duly, impartially carry out the law is just going to end up giving them over more powers to prosecute people like us. So it's not encouraging. So there's some things in here, and it says, first of all, it goes into the costs associated with importing this kind of ethno-religious tension that we saw on the pro-Palestine protests. The Met Police state the costs of policing the Palestine protests in London between October 2023 and June 2024 were £42.9 million, with 51,799 Metropolitan Police officers shifts and 9,639 police officer shifts from officers usually based outside the Metropolitan Police area. The 6,339 police officers had rest days cancelled between October and April 2024, all of which were to be repaid in due course. Bear in mind, as we've covered repeatedly on this podcast, the exact kind of population to go on these pro-Palestine protests are not net tax contributors. So they are frustrating our capital city every weekend of Wednesday.
So this is even more of a drain.
Exactly. So these people are costing us money anyway, and now they're costing us extra money to agitate for a foreign war on behalf of a prescribed terror group. Bear in mind, this happened in the aftermath of October the 7th, not in the aftermath of Israel's response to the October the 7th, so it was a celebration of what Hamas has done, not a complaint about how Israel responded. The same population as well, same host population paying for it, don't want to visit their own capital city during these protests. As a Londoner, I can agree. Polling was conducted by Policy Exchange, and it showed members of the public are choosing not to engage in a wide range of activities because of these protests. They dropped their plans to travel with small children, 71%, travel with an elderly or mobility impaired friend or relative, 69%, visit a tourist attraction, 62%, go shopping, 58%, and eat at a specific restaurant, 58%. So more costs, economic, but also cultural, spiritual, if the host population are being demoralised and chased out of their own capital city.
Oh yeah, I can speak from my own personal experience. I've not been to London in, at the very least, over a year, and I have no intention to go back if I can avoid it. Why would I go there?
It feels like navigating the rubble of the Tower of Babel at this point. It's really unpleasant. It's smelly, it's busy, it's expensive. I want to get out as quickly as possible. The main headline that came out of this report that everyone was reporting on, they did an interview with Assistant Commissioner to the Metropolitan Police, Matt Twist, and he said the following: "When we look back at the policing of protests over the last 8 months, we know we didn't get everything right, particularly in the early stages of October. We've developed our tactics since then, becoming faster and more decisive. On an occasion, we did not move quickly to make arrests. For example, the man chanting for jihad, which was a decision made following fast time advice from lawyers and the CPS. So guidance provided by the 700-strong Muslim activist network in the Home Office and pro-immigration lawyers, which usually have an ethnic and religious bias, are advising the Met not to crack down on people chanting for intifada and jihad. I wonder why." He said, "We are now much more focused on identifying reasonable grounds for arrest, acting where needed, and then investigating, so in these circumstances it's very likely arrests would be made more quickly now." Oh, it's very likely arrests would be made more quickly now in the aftermath of another set of protests which were the indigenous population protesting, and so now you're going to get much harder on it. Isn't that fascinating? I wonder if anyone from the post-Southport protests or one of Mr. Robinson's rallies, not you, other one, would have chanted from the Channel to the Irish Sea, Britain will be free. They'd be locked up in handcuffs, but not the other way around. Got it. Also, an important detail that they find here. So in order to stage a protest in Britain, you have to give the authorities 6 days warning if you want to do a large-scale march. The Palestine Solidarity Campaign contacted the Metropolitan Police to inform them of their intention to conduct their first mass Palestine protest 10 hours after the terrorist attack on October 7th. Right. So, not protesting the gross injustices by the Israeli regime, just open ethno-religious solidarity and celebrating murders? Why were any of these allowed? Letter of the law could have stopped them at any time, but it doesn't. That's most important. So, the recommended response was that the government should legislate to establish a protest commission for London. A protest commission for London. Involving independent commissioners. Independent. As we always know, there is no such thing. There's no such thing as a neutral process. It's always political. Appointed by the Home Secretary following consultation with the Mayor of London. Independent. Appointed by the Labour Home Secretary and the Labour Mayor of London, both of whom endorsed and oversaw the protests. Great suggestion. The government should amend Section 11 of the Public Order Act 1986 to increase the notification period for all protest marches to 28 days.
But they'll just step over that.
Or they'll
if
just
they want to.
They'll let the ones they like go ahead and they'll ban the ones they don't like,
Yep.
which they do anyway. The government should legislate to require the police forces must take action to prevent the interference by protesters with the operation of those installations of facilities classified as key national infrastructure, and expand the definition of national infrastructure under the Public Order Act 2023 to include Parliament, government departments, and the courts. So they're anticipating some sort of physical attack on government, parliaments, and the courts? Because the only thing I can think of in recent memory was the protest outside the ceasefire debate where they projected from the river to the sea on Big Ben, but they knew where the projector was. Martin Daubney pointed out, and the Met Police just shrugged their shoulders and didn't arrest anyone, didn't even turn it off. So again, choices were made here. They could have done it at any time. They also should make it unlawful for individuals at protests to wear face coverings. So a couple of years after mandating them, they're now going to make them illegal. Again, I don't like face coverings, but I would feel comfortable with people wearing face coverings if they weren't a demographic more likely to commit violence against me for ideological or impulse control reasons. Sadiq Khan should also apparently conduct an equality impact of the protests on businesses, tourism and threats to women, the disabled and the elderly, which I'm sure he'll do completely impartially, just as he did with the ULEZ. The Commissioner of the Met Police must take all possible steps to ensure all those that are suspected of committing criminal offences at protests are arrested at the time of the offence. So the police should do their jobs. That's an actual recommendation in a policy report in modern Britain.
But as well, we saw with the Southport riots and protests that went on that the Metropolitan Police will just hoover up anybody if they feel like it, depending on the cause of the protest in the first place.
Yes, but if it inflames community tensions at Notting Hill Carnival, the Palestine riots, they'll let people go and sort of lazily try and track them down comfortably from their desk with a cup of tea and a packet of biscuits afterwards. And maybe they might perform some arrests. And even then they'll say, oh, a small minority were ruining it for the rest of us. How could they? There's also this reminder, right? Provided in the executive summary. Central to these events is the claim of a right to protest, despite there being no such explicit and unfettered right within the ECHR or the Human Rights Act 1998. Instead of a right to protest, the following articles are allowing people to protest. Article 11, right to freedom of peaceful assembly and association, and Article 10, the right to freedom of expression. Both rights are explicitly qualified by restrictions as prescribed by law and are necessary in a democratic society, among other things, in the interest of national security or public safety, for the prevention of disorder and crime, protection of health and morals, protection of the rights of others, etc., etc. So all of these are nebulous definitions, and they just allow the state to pretend that they're ratifying and making impartial decisions on human rights, and instead punish their political enemies and favour their political friends. And the perfect example of this is the recommendation in here that the Crown Prosecution Service must amend its legal guidance on offences during protests, demonstrations or campaigns to reduce the likelihood of suspects not being prosecuted for public interest reasons. That's literally what the judge said in Sweeney's case. So we're going to teach you keyboard warriors a lesson. None of that was said about Arif, even though we had the Palestine marches and we had those armed Muslims in Jess Phillips's own constituency, there wasn't a need to talk about democratic principles or a chilling effect there. Just give him a few weeks, few months in prison and keep him shut up about it. Again, this is what I found. I remembered this. You tweeted this out a while ago. This is your law, Harry's law in effect. You tweeted out, no matter its intended foreign target, anti-terrorist technology and intelligence departments will be inevitably used to spy on and imprison white European populations. This is exactly that.
Well, if the purpose of a system is what it does, then the purpose of the UK government is to punish the British people.
Quite, yes. Perfect example of this is the Equality Act. The Equality Act that people keep saying we need to appeal to get gender-critical wins, for example. This chap, Mr. S. Thomas, bear in mind, he does use social media like a boomer in here, so I will point that out. He went to an employment tribunal about the NHS, claiming that he, as a contractor, had been discriminated against for his English nationalist views. So the point of the Equality Act is it's meant to protect certain characteristics, as in the government's favoured ones, and certain beliefs from discrimination in employment. So, for example, it's intersectionality codified in law. You can obviously actively, positively discriminate against white, straight Christian men, but you can't discriminate against black women, for example. The recent win that we supposedly got was the Maya Forstater case, where gender-critical, aka believing in biological sex, beliefs are now protected characteristic under the Equality Act. But it just shows that even if you try and appeal to the Equality Act to get wins, they will just selectively apply it, if and where. Because this chap, the judge ruled, said, by the end of the hearing, Employment Judge Hyde considered the third question from the list of issues was more properly posed as, were his anti-Islamic views worthy of respect in a democratic society, incompatible with human dignity, and did they conflict with the fundamental rights of others such that they would prevent the claimant's belief in English nationalism from being a protected characteristic? AKA, did they offend Muslims, therefore, can we fire him from his job? And they say, to the claimant, and he identifies his views. So the claimant, English nationalism is the nationalism that asserts the English are a nation and promotes, bless you,
Thank you,
the cultural unity of English people. The claimant's focus is on national identity, which does not depend on ancestry or race rather than common descent or race. So he's very boomer, civic nationalism, England is a set of values, ideals, and even that is too far gone for the Equality Act. So he's not even arguing for protection on the basis of ethnicity or racial identity. He's arguing for the protection on the basis of values. And even then, they're making the discrimination against which values are preferred by the state versus which values are prescribed by the state.
They're saying, sorry, mate, Britain is gay race communism values.
Exactly. So the decision was this. Judge Hyde observed in cross-examination before the Leeds Employment Tribunal, the claimant has said that Islam in its current form should be banned from England unless it were anglicised and toned down to fit within society in England. So even then he's being quite generous. Employment Judge Hyde commented at the hearing before her, the claimant did not dispute these comments were consistent with his English nationalism. The claimant alleged his assignment within the NHS Trust had been terminated because of his belief in English nationalism. He claimed this was belief discriminatory contrary to the Equality Act 2010. At a hearing, the Employment Tribunal held the claimant's belief was not protected by the Equality Act. The claimant appealed this decision. The appeal is dismissed. The claimant's views are of an English nationalism which believes there is no place in British society for Muslims or Islam itself. Among the claimant's views are that the Muslims should be forcibly deported from the United Kingdom. These views are not capable of protection under the European Convention on Human Rights, as they would offend Article 17, which provides that nothing in this convention may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any rights and freedoms set forth herein at the limitation to a greater extent that's provided in the convention. The claimant is not prevented from holding his views, but he is outside of the right to complain that he has been discriminated against in relation to those beliefs in the circumstances covered by the EQA. It's obvious that he's been discriminated against on the grounds of his belief, because this is happening in the judgment. And so what the Equality Act exists to do is designate certain beliefs and certain characteristics above certain others and afford them certain legal protections over the indigenous host population. And I don't necessarily want to use the Equality Act for any of this. I would rather the entire thing was scrapped. But the point matters that who applies the law matters less than the consistent letter of the law. And here's a great example. Mel B and some Labour politician for Birmingham Erdington, Paulette Hamilton MP, are trying to bring forth an amendment to protect Afro hair under the Equality Act.
No. If it was up to me, no. I mean, again, we'd scrap the whole thing if it was up to me. But this is frivolous.
Yeah, well, you're in a joke of a country, so actually, our favourite independent journalist, Kani Drukpa, has given us a vision of the future. You're under arrest for describing a mixed-race woman's hair as frizzy without an Afro hair ally licence, which is a serious crime. It's all in here, mate. You're going away for a long time. Makes me sick there are people like you walking the streets. Well, not for much longer. You think I'm joking?
I mean, I've seen him post a few of these with this particular gentleman, particular officer, holding up a variety of books. The Second Treatise on Government.
Second Sex was one of them.
The Second Sex, Vindication of the Rights of Women. It's all in here, mate. It's all in here. This is why we're doing this.
Set text by the College of Policing. Now, look, I'll wrap this up because you think I'm joking. I wish we weren't a joke of a country, because this actually could be possible, because Yvette Cooper is bringing back non-crime hate incidents. And we say bringing back because friend of the show, Harry Miller, in 2021 took the College of Policing to court, and it was ruled that the way they were recording these non-crime hate incidents was unlawful. They were giving you a black mark on your DBS check, not informing you of who had made the claim, what evidence the claim was, and if you had a claim against you, and so you could be turned down for jobs without ever knowing why. And because there's no evidentiary standard, the people that were making the claim were treated automatically as the victims and you as perpetrators, even though they're not crimes. He had found that between 2014, when these were adopted as a result of the Macpherson report, and 2020, over 120,000 of these have been recorded. We now estimate 250,000 of these have been recorded. And despite Suella Braverman in 2023 putting in the Police Crime Sentencing and Courts Bill new legislation and guidance being given to the College of Policing to stop recording these for frivolous reasons, they went up last year. The law does not matter. 30 of the 43 police forces in England and Wales increased the number of non-crime hate incidents they recorded. So, I just want to reiterate for everyone, and you can find out more about these stats in a recent episode of my show that I did there. I broke it down for an hour and a half. It's very laborious, but hopefully a useful resource. The point of this segment is to reiterate, as Thomas Hobbes once said, autoritas non veritas facit legem. Authority, not truth, makes law, and the people applying the law are the authority. That matters more than its letter. It's not on our side.
I hope you appreciated that segment from the podcast The Lotus Eaters, and if you want to see what else we're putting out, you can see this speech from Carl, and if you want to see all the other work that we're putting out, you can follow us on Twitter, where we post links to everything. Thank you very much for watching, and goodbye.